South Australia, 3 Rogers v. Whittaker, 1993, Supreme Court of New South Wales, 4 Millett Fire, Shulman, 1990, Supreme Court of Ontario 5, Secretary, Department of Health and Community Services, NT, VJWB and SMB, famously known as Marion's Case, 1992, High Court of Australia. The majority view on the concept of passive euthanasia and Article 21 of the Constitution of India. Expressing the majority view on passive euthanasia and Article 21, it was stated that it is critical that the court come to the conclusion that Article 21 permits passive euthanasia so that it can establish the rules for its regulation. The authority to establish the rules is known as judicial legislation, which is the applicability of legislation to new or unexpected demands and circumstances. Chief Justice Deepak Misra stated that the application of fundamental rights must be flexible, as stated in numerous judgments. K.S. Puttaswamy v. Union of India, 2017, clarified that Article 21 includes the concept of individual dignity. According to Chief Justice Misra, it corrodes the essence of dignity to let a sufferer wait for death while not knowing whether or not they are still alive. Death does not indicate the disappearance of dignity, because dignity does not require any connection to a person's condition. Thus, under Article 21, a terminally sick individual or one who is in a permanent vegetative condition might choose to have his life end prematurely. This is a fundamental human right. Hence, there is no need for legislation on this subject. Also, it is specifically stated that Article 21 permits only passive euthanasia. The majority of opinion holders referred to the following cases while giving judgment on Article 21 and passive euthanasia. 1 Board of Trustees of the Port of Bombay v. Dilip Kumar Raghavendranath Nadkarni and others, 1982, High Court of Bombay 2 Maneka Gandhi, Burfuri, Union of India, 1978, Supreme Court of India, 3 Central Inland Water Transport Corporation Limited, and another VI, Brojo Nath Ganguly and another, 1986, Supreme Court of India Forum Nagaraj and others v. Union of India and others 2007, Supreme Court of India 5 V.C. Rangadurai V.D. Gopalan and others, 1978, Supreme Court of India 6 K.S. Puttaswamy v. Torres, Union of India, 2017, Supreme Court of India. The majority view the autonomy of an individual and the right to self-determination. A person's ability to practice self-determination as well as autonomy involves whether or not they are willing to conform to clinical procedures and therapies. Aruna Shanbag's case highlighted that one has the option of choosing the method of treatment only if they have a sense of self-determination. If a patient lacks the mental capacity to make decisions, their preferences, as expressed in a living will or by agents acting on their behalf, should be honored. These preferences would be known as substituted judgments. The caregiver must act in the patient's best interest and cannot let personal beliefs, motivations, or other factors persuade their decisions. According to Chief Justice Misra, if a doctor is satisfied that a patient's condition is fatal, they are obligated to follow their patient's wishes. The patient's best interest cannot be served by any other factor. The majority view on the issues concerning medical ethics, societal morality code of conduct, and state interest. In order to resolve the issues of medical ethics, social morality, societal code of conduct, and state interest, Chief Justice Misra makes it clear that stopping medication in an irreparable condition is distinct from discontinuing patient care altogether. He continues by asserting that such concerns and pity are out of place once passive euthanasia is acknowledged by the law as defending the right to die in dignity. The majority view on the inclusion of an advanced medical care directive. The phrase advanced medical directives describes a person's medical choices and names the people who will make those choices if the person is unable to express his preferences to a physician. Instead of using the word living will, Chief Justice Misra offered recommendations for advanced medical directives. Only an individual who is above 18 years of age, of sound mind, able to speak, and capable of understanding the aim and implications of advanced medical directives may carry out one such directive. It must be carried out voluntarily and free from coercion, undue influence, or constraint. It must be in writing and explicitly state how and when medical care may be stopped or discontinued. It should state that the executor of the Advance Medical Directive is always free to withdraw the instructions. It should include the name of the caregiver or immediate family member, who will be permitted to consent to, decline, or discontinue medical treatment in accordance with the Advanced Medical Directive. The most recently signed Advanced Medical Directive will be taken into account, if there are